Good morning or good afternoon, everyone. We're just going to wait a few minutes for some stragglers and we'll start shortly. We'll give it another minute. Okay, we'll get started now. Good afternoon, everyone. First of all, I want to thank you all for attending today's webinar. On behalf of SCORE, my name is Bart Sharp. I am co-chair of Staten Island chapter, along with Gina Otrando, who's on the screen also. I'd like to, first of all, I'm going to make little notes here. Thank everyone for showing again, but SCORE is sponsoring this webinar, and our mission statement is to foster vibrant small business communities through mentoring and education. Sponsoring this webinar is part of that mission statement. And first of all, in charge of Annamarie Gentile, an attorney and supervising partner of the firm of Angiuli and Gentile, will be putting on this webinar. Annamarie is a founder and supervising partner at the law firm of Angiuli and Gentile. In addition to overseeing all areas of the firm practice, Annamarie is the firm's lead attorney in the estate planning and elder law division. She counsels families on how to plan their estates to achieve their personal goals with an eye toward preserving assets for the benefits of future generations. Her estate planning work includes drafting documents, wills, trusts, and so forth. We're talking about her estate planning work includes drafting. I'm losing my place, everybody. I apologize for that. An agreement in connection with planning their estates. Annamarie advises clients on business succession issues, charitable, gifting, probate, administration matters, trust administration, related litigation. So that's enough that I can say about Annamarie. She did a lot more than that, I'm sure. So with that, I will turn it over. But first of all, Annamarie, can you flip to the next slide? Thank you.
Yes, sir.
Just a few housekeeping. Your line will be muted. And when you have a question, if you can use the Q&A as opposed to chat. Copies of the slides and video presentation will be sent to all attendees. And I appreciate it if after the webinar, if you complete a brief survey that will be sent to you at the end of the webinar, which will help us plan other webinars in the future. With that, Annamarie, I'll let you take over from here. Okay.
Thank you very much, Bart and Gina. And as Bart said, thank you very much for joining us, everybody, especially on this beautiful day. I'm honored that you're taking the time out to be inside and joining this webinar. So as Bart said, I am Annamarie Gentile, a practicing attorney on Staten Island for I believe 42 years. Oh my goodness, I don't know where the time has gone. Just a little bit of a background on myself. I did start out as a assistant corporation counsel with the city of New York, and I was a litigator in the tort division. When I went into private practice, I did go into litigation, but I realized maybe because I was blessed to have my grandmother in my life, and she lived to be 102 years old, and so I had the joy of being around her and her contemporaries. But I realized that there was a great need for us to have some way of disseminating information to our senior population as to steps that could be taken to protect what they worked so hard for and provide for their families, and also to get care that they may need to help them to age gracefully in the community. And so while estate planning isn't only for the elderly, it is important for everyone at all different stages of life to have a direction that I think they want to take their estate in. And over the years, of course, things can be tweaked. And today we're going to speak about some major topics of elder law and estate planning, but there's so much more. So before I get into the actual program, I just want to offer to all of you the opportunity to contact us at Angiuli and Gentile going forward, and just mention that you were on this webinar, and I will be more than happy to extend to you a complimentary consultation here at the office to talk about your personal estate planning goals and review documents for you and whatever else you may need. So with that, I am going to go to our first slide, which is a presentation overview. So there's so much to talk about in the area of estate planning, and I'm trying to focus on the main topics, and then with also an understanding that some of you are small business owners out there. So we will, at the end of the presentation, try to cover some important aspects of some things that you can have in your arsenal as a small business owner when it comes to planning your estate. But the presentation overview will be basic estate planning documents that we'll speak about, some estate planning techniques. We'll talk about the need for short-term and long-term care going forward in life, because the longer that we live, the more apt the statistics tell us we are to need some assistance with our activities of daily living. So we will speak a little bit about how to prepare for that possibility and ultimately how those things can be financed. We're also going to spend some time about protecting our assets, ways that we can begin to do that when we're not in an emergency situation. Of course, if we are in an emergency situation, please don't feel that all is lost. We can assist in protecting assets even at a late stage. And we will talk about long-term care. What does that mean? What kinds of long-term care are there? How can we avail ourselves of these things? And how is long-term care paid for? And then, as I said, we will touch on some concerns of small business owners. At the end of the presentation, I'm more than happy to answer any questions that you may have. And again, as I said, if you have personal questions, please feel free to make an appointment to come in and meet with me privately. All right. So with regard to the basic estate planning documents, the first one, and you guys have probably heard of many of these things, but it does merit discussing them. And the first one is the healthcare proxy. So this is where you designate who can stand in your shoes in the event that you're unable to make your own health-related decisions. People oftentimes think that a spouse can legally make health-related decisions for them, but that is not true. In practicality, many times doctors or medical care practitioners will speak to the spouse, but that is not a legal requirement. So in order to have in place who you want to make your decisions in the event that you cannot, it's important to appoint them in a legally drafted healthcare proxy. And again, this is designating someone only if you're unable to make your decision. You will avoid having to bring any kind of court proceeding, or your loved ones, I should say, would avoid that, because legal guardianship is the alternative to being able to make decisions in the event that your loved one cannot. So with the healthcare proxy, you can stand in his or her shoes, and that can be for a temporary period of time, or it can be for a permanent period of time. So that's a very important document that will help you during your lifetime. Okay, our next document is going to be the power of attorney. Oh, I'm sorry, it's the living will on our next slide. The living will goes hand in hand with the healthcare proxy, and this is going to let everyone, your loved ones, the doctors, the hospital personnel, it will let them know what your wishes would be in the event that you were at an end of life stage. And typically, end of life stage would mean you're incurably ill with no hope of recovery. And the only way that you could be kept alive is by hooking you up to various artificial life support systems. So this is important to have into place because number one, I don't think want to leave that burden on your family members. And number two, it does express in writing for the physicians to see what your wishes would be at an end of life stage. And, I always say to my clients that the doctors take the Hippocratic Oath to really do everything they can to make us healthy and to keep us alive for as long as possible. And so sometimes they might be in a conflicting state if they feel that by allowing someone not to be put on life-sustaining measures, they may be assisting in accelerating someone's passing. But my experience has been that when they see the living will in writing from the actual patient, it makes them more comfortable in following what those wishes would be. So therefore, it is a very important document to have. The next document is going to be our power of attorney. Like the healthcare proxy, it allows you to appoint who you want to stand in your shoes to make decisions. But for this one, it's for everything other than healthcare decisions. So think of anything that you could do in your day-to-day living. It could be things like going into a bank and doing some banking transaction. It could be getting on the telephone with an insurance company or dealing with the Social Security Administration. It really is for anything. And entering into a power of attorney allows you to choose who you think would best fit that situation and who would best manage your legal and your financial affairs in the event that you're either unable, again, temporarily or even permanently. This will avoid a lengthy guardianship proceeding, and you can revoke the power of attorney. You can change it. You can appoint someone else if that situation becomes apparent. And so it's not like something with finality where you're married to it forever. So I strongly encourage everyone to have a power of attorney as part of their estate planning document package. Okay. The last will and testament. This is what we traditionally know to be the way that we pass on our assets to those who we love and those who we want to get whatever it is that we have when we pass away. Remember, first of all, that although you could prepare a last will and testament at any time, it is going to control what it is that you have when you die. It will likely be different things than what you have when you make out your last will and testament. So it is a good idea, I would say, every 2 to 3 years to revisit your estate plan. If it's your last will and testament, it could be a trust, it could be a combination, but you should revisit these documents, and especially if you have some kind of important events that have occurred in your life. It could be that you're retiring. It could be the birth of a child or grandchildren. It could be death of someone important in your life. All of these things may prompt you to want to change the document that you prepared. And that holds true definitely for your last will and testament. The thing about a last will and testament is that it must be prepared properly. If it's not prepared properly, it will not be accepted by the surrogate in the probate process. That is the court process where a will is presented to the surrogate's court and in the jurisdiction where the person resided upon their death, and the surrogate in that court, the judge, will determine whether or not the will was prepared properly and therefore whether it can be given credence. So it's very important to have your will prepared by an attorney who is knowledgeable in the area of estate practice. If you live in New York State, your will is going to be prepared and executed in compliance with the laws of New York State. However, it is valid in all 50 states. So if you move somewhere else, it doesn't mean that you have to necessarily redo your will, at least not for just the fact that you moved. Within your will, you will be stating what you want to be distributed and how you want it to be distributed. You will designate who your executor is in your will. This is the person who's going to be charged with carrying out your wishes someday. And there are other things that can be built into your will, which are important. Different kinds of trusts. We call them testamentary trusts when they're in a will, because they come into play once you die. And these trusts can help with people who have special needs. They can help with distributing assets to minors. They can appoint guardians for minor children if you're preparing a will when you have minor children. So these components of a will are very helpful in specific situations that different individuals may have. The thing about a will is that if there are any assets that do not have designated beneficiaries on them. So for example, if you have bank accounts, if you have retirement accounts, if you have investment accounts, I strongly encourage you to have not only beneficiaries designated, but also contingent beneficiaries, because having that in place will ensure that those people will get whatever it is, the account or the asset, just by showing a death certificate once you pass away. They will not have to go through the process of probating your will to get assets that they're designated as beneficiaries on. But there are certain assets, for example, real estate, where we can't designate beneficiaries. A deed does not allow us to put a beneficiary designation, period. That's the way it is. So if we own real estate in our name when we die, and there's not a joint owner on that, it is going to prompt the need to probate the will. And so I don't know if you've ever heard about the process of probate, but I have many clients who come into me and they have heard about it and they say, Annamarie, I definitely want to avoid probate. So if that's one of your goals, the last will and testament is not going to help with avoiding probate. So, when we talk about avoiding probate, we're going to have to discuss other tools that we can use to help us in conjunction with designating beneficiaries on things that we can, other tools that can help us to avoid probate. And we will get to that when we start to speak about trust in a minute or two. I did want to just let you know some information. I don't know if any of you happen to be on the webinar that I gave for SCORE back, I believe it was in 2022, where we discussed some of these issues as well. But there have been some increasingly large changes that have resulted in either exemptions as to deductions that we have when we die, as to estate taxes being required or not. And as we go through this presentation, I'll also be speaking about other increases in assets that people can have and still qualify for different benefits programs and things like that. So I wanted to bring these things to your attention, and also just to let you know that you will be getting these slides from SCORE. So the information that I'm speaking to you about today is going to be given to you in, what you can print out for yourselves if you'd like, or to save it on your computers. So one of the things that we have to know, it's very important, is that between spouses, there is an unlimited marital deduction. What that means is that when the first spouse dies, we don't have to concern ourselves with the payment of estate taxes, because passing assets to a spouse is passed tax-free when it comes to estate taxes. Now, that sounds terrific, but it's not the be-all and end-all, because the time is going to come where the second spouse passes away. And with that, now, whatever there is going to pass to the next level of beneficiaries. And oftentimes, those are children or grandchildren. So when we do our estate planning, we want to plan it in such a way that for people who have considerable wealth that is beyond the amount that as an individual they could pass on tax-free, we want to plan their estate in such a way that their next level of beneficiaries can benefit from the exemption of the one spouse, let's say the father, and then the second spouse, let's say the mother, without losing any of those exempt values. So right now, for an individual, the federal estate tax exclusion amount is $13.6 million. And so for a couple, it's $27 million. And it is what we call portable. So if we're blessed to have that kind of an estate, we know that on a federal level, if your estate is planned properly, you can pass on up to $27 million of assets for a couple without any estate tax consequences for your children or grandchildren or other beneficiaries. So this is very, very important, and it is increasing. It has increased year after year for many years now. We don't know if this is going to be dialed back. It's scheduled to be dialed back, but we don't know, and that will depend on, I think, the political party in power at the time that this sunsets. And I do believe that's going to be, well, don't hold me to this, but it's either going to be in 25 or 26 that that's supposed to go back down to a much lower level. On the New York State level, right now we have an exclusion against estate taxes of almost $7 million, $6.94 million for an individual, but it is not portable. So we can't say it's 12 million or 13 million for a couple. It's 6.9 million for an individual. So in doing our estate planning, we want to take whatever steps we can to also give the benefit to the next generation of as much of that as possible. Also, a lot of people know of this gifting. People will come into me and say, oh, I can make $10,000 a year of gifts without any tax consequences. Well, yes, it used to be 10,000, and it has also gradually increased, where it's now, believe it or not, $18,000 per year that an individual can give to any number of people and not even have a tax consequence at all, and not even have to file any kind of tax return. So anything up to $18,000 per person, you can give it as a gift, and it's going to be tax-free and document-free. So avoiding probate. This is what we were talking about a minute ago with regard to the will. People want to avoid probate, and I encourage that, because lawyers make legal fees in probating wills, but for everybody else, especially the family members, it really is a burden. It is time consuming. It's costly, not only for the legal fees, but also for the court fees. There are court filing fees. There are fees that sometimes have to be paid to court attorneys, all different kinds of things that can be avoided in advance by a combination, as we were saying, of titling assets with beneficiaries or jointly titling assets. And with regard to real estate, thinking about utilizing a trust to title your real estate in. Now, when we speak about trusts, there are two general categories of trusts: irrevocable and revocable. These trusts overlap in some ways, but they also are distinctly different. So let's start with the revocable living trust, which I have up on the screen right now. With the revocable trust, you, the individual creating the trust, typically called the grantor, may be your own trustee during your lifetime. So what that means is that you are going to have full control over all of your assets. It's actually an identity of ownership to you as an individual. The reason why you would choose to use a revocable trust is because it will allow you to avoid probate. If you title assets that would otherwise have to go through probate in the name of the revocable trust, and oftentimes this is real estate. It's because your successor trustee, who you will name at the time you create your trust, who takes the role on of trustee upon your passing, will have the legal authority to carry out the wishes that you stated in your trust once you die. There's no need to go to court and have a judge authorize your successor trustee to be able to carry out those wishes. The successor trustee will be able to follow what your wishes were, gather your assets, and ultimately distribute them as directed to do so in your living revocable trust. This sounds great, but the revocable trust does not afford any protected status to assets that you have. So when one of your goals, if it is one of your goals with your estate planning, is to protect assets, perhaps from the cost of long-term care in the event you should end up needing long-term care in a facility or even at home at some time in the future, anything that you titled in a revocable trust is going to remain vulnerable and won't have any protection associated with it. So in order to get the protection, we're going to go to the next slide and we're going to speak a little bit about the irrevocable trust. As a revocable trust avoids probate, so does an irrevocable trust. But it also gives the benefit of beginning to protect assets that are titled in the irrevocable trust. And this takes some time. It takes 5 years from the date of transferring the assets into the irrevocable trust for them to be protected from the cost of long-term care in an institutional setting, like a nursing home. And it takes 30 months or 2.5 years to protect transferred assets for the purposes of home care through Medicaid, through the Medicaid program called Community Medicaid. Just as an aside, I want to mention that when I speak about Community Medicaid, which you'll hear me talking about more as we go along today, I am speaking about a program that it has been created for the benefit of senior citizens and disabled people. So when you think sometimes about Medicaid, you may think about a form of medical coverage that traditionally is for those who can't afford health insurance, or maybe they had some kind of catastrophic event in their lives where their medical costs are so exorbitant that even with health insurance, they would never be able to pay for the cost of care that they need. But when I speak about community Medicaid, I am really speaking about a program that is for specifically long-term care needs. And this is, as I said, for seniors and for disabled persons. And so it actually is a combination of using your Medicare, which if you're a senior, that is typically your health insurance, in conjunction with Medicaid for things that Medicare does not cover. One thing of which, very importantly, is the cost of long-term care. So by taking steps to begin to prepare your estate, one of the things that we may be looking to do is to begin to create eligibility for future needs for long-term care in your home or in the community under the Community Medicaid program. Okay, let's go to our next slide. Okay, so asset transfers and Medicaid. There are certain times where we can transfer assets without any of this penalty period that I'm speaking of. For example, your home can be transferred to your spouse, to a disabled child, or to a sibling of yours who has lived in your home for at least 1 year and who also has an equity interest in the property. So let's say your parents left you and your brother the family home and you both live there, and now you're needing to avail yourself of community Medicaid. You can convey your ownership interest to your sibling without having to be worried about that 2.5-year penalty period. Also, transferring a home to a caretaker child who has resided with you in the home for at least 2 years prior to needing either home care or having to go into a nursing home would also be an exempt transfer. The penalty period that we use for asset transfers is something that we are using under the laws of and rules of Medicaid. And even though I'm saying that currently there's a 2.5-year penalty period for community Medicaid, believe it or not, this law went on the books in 2020. It still has not been activated. So fortunately, for people who are in need of home care, we can still take steps at least until the end of 2024. This is currently the deadline, December 31st of 2024, where we can transfer assets for people without them having to wait 2.5 years to apply for community Medicaid. Unfortunately, it doesn't appear that that is going to be further extended. So while we've been fortunate to have the ability to continue to plan for the past 4 years, we need to do it now. And we want to be safe for people who need care, that they get their transfers and their application done and in before the end of this year. For long-term care, the general places where people can get long-term care are things like assisted living facilities, home care, as I've been touching on, and nursing home care, which is a skilled nursing facility, typically for people who have advanced needs where they do need 24/7 care to be at least there available for them. When we talk about assisted living facilities, we sometimes don't realize that these are limited in what kind of care we get for what we pay to be in the assisted living facility. Generally speaking, it's exactly what it says, for assistance, but it's not personalized assistance. It's not that when you go into an assisted living facility, you're assigned an aide or someone who's going to take care of your specific needs. It means that in general, there are people there who can help with certain aspects of the activities of daily living. For example, usually meals are prepared and there's a roof over your head, things of that nature. But if you need specific care, let's say you're in need of help showering, you're in need of assistance with your medications, things of those natures, that will require you to pay additional for that, or to be part of a plan like Community Medicaid, where you'll have your own aide who will be assisting you according to the plan that has been prepared for you under the Community Medicaid program. So it's important to keep that in mind, because there can be out-of-pocket expenses. Under the home care program, again, the way it works is that there are out-of-pocket expenses that you're trying to avoid by qualifying for home care to be paid for by the combination of being a Medicare recipient that will continue to cover your medical expenses, hospital expenses, and things of that nature. But the home care component of an aide and other services that Medicare doesn't cover, for example, transportation to and from doctor visits, nutritional supplements like Boost and Shore, adult diapers, all different kinds of hearing aids, things that Medicare doesn't cover. The hope would be that under your Community Medicaid program, you would be able to avail yourself of those kinds of services, included free of charge. Okay, to finance long-term care, Medicare is going to help with short-term care. So if you go into a hospital and have surgery, or you're in a hospital for an illness, and then you are discharged either to home or sometimes to a short-term rehab facility, typically Medicare will be the payor for that care. But that is very limited. It's limited in time. It's a maximum of 100 days. And also in the amount of care you get if you do go home. So it could be, a couple days a week, and it could be a couple of hours a day. So many times we need more care than that when we are recuperating. So, but you may have to pay for the additional care privately. Also, there is long-term care insurance that is typically a component of people's long-term care, estate planning, and all that goes into it. I am not an insurance agent, so I can't speak with specifics as to long-term care, but I can say that I have had many clients who have some kind of long-term care in place, and usually it is not enough. It is something, it is good to have, but it's either going to be limited in the dollar amount, the number of years that it can be used for, or the different kinds of services that are provided under the long-term care policy. So because of this, we do recommend planning for your own situation, and this is where the advanced planning under having certain kinds of transfers take place and funding, perhaps an irrevocable trust, becomes very important. I'm going to skip over Medicare because I did mention what that covers in the short-term care realm. And now we're into the Medicaid nursing home or institutional care discussion. So as of January 1st of 2024, an individual, in order to be eligible for Medicaid for long-term care, be it home care or institutional care, may not have in excess of $31,174.20. I looked back on my program that I presented only 2 years ago, and believe it or not, that figure was about $17,000. So it is unbelievable to those of us who practice in this area that it has almost doubled. But still, as we're talking about this, it is a very low number. If you own your home and that's in your name, of course it's worth more than $31,000. So we have to talk about how do we legally get people to a level where they can qualify for this very important care that they may need as they age. And this is, again, in the home as well as if they had to go into a facility. So when we transfer assets, we utilize the different kinds of techniques like the irrevocable trust to satisfy Medicaid's rules so that if the need comes where the individual has to get care, the steps that have been taken up to that point in time are going to be accepted by Medicaid as sufficient to distance those assets enough that they're not going to be considered an asset in the application process, nor will they be reachable for a lien to be put on them once the person begins to receive Medicaid. This is so important, and it really takes understanding and having someone in your corner, specifically an elder law attorney, to let you know how that has to take place. As of October of 2020, as I've mentioned, you have that 2.5-year look-back period for community Medicaid, but we're not worrying about that at the present moment. We will have to begin to worry about that as of January 1st of 25. When we have the need for community Medicaid, so this is the care at home, not only are there asset requirements, but there are also income requirements. And you're going to see here this figure of $1731.90 per month that an individual could have to qualify for Medicaid to come into the home and provide these long-term care services without the individual either having to contribute into the program or spend down their money, their excess monthly income before being eligible. We suggest using what's called the pooled income trust for people whose monthly income is over that amount. And I don't really have time to go into it with detail, but the end result of utilizing the pooled income trust with the community Medicaid program is that even if you have $5,000 a month or even $10,000 a month in monthly income, we can take the steps to qualify you for the program and not have you lose the ability to utilize all of your monthly income without having to just lose it by paying it into the Medicaid program. It can be used to pay for your monthly expenses. And your monthly expenses are usually a lot more than you think, because some of the expenses that you have may come on a quarterly basis, on a semi-annual basis, or sometimes even on an annual basis. So we can amateurize those payments, and they will be included in what your monthly bills or expenses are. And so your money that you have coming in every month can be used through the pooled income trust program to enable you to maximize the services that you get under Medicaid, but also the money that you have to pay for all of those expenses that you have on your usual, monthly budget. We spoke a little bit about long-term care insurance, so I will skip that at this point. It's very important to remember that whatever you're doing for your estate planning needs to be tailored to your own individual needs. What your relatives do, what your neighbors do, your friends, could be completely different than what you need. And this is why I encourage you to speak to an elder law attorney with regard to your specific needs. We don't want to have a situation. I have people coming in saying, oh yes, 10 years ago, we did what my brother did, a revocable trust, and mom now needs long-term care. So I'm sure we're fine, right? We're not going to have to, our assets are protected. And unfortunately, I have to explain to them that no, they're not protected. And, they say, but why did this attorney tell me to do that? And I say, well, I wasn't there, so I don't know what happened at that time, but it's important to speak with someone with regard to your personal circumstances. Show the attorney who you choose to work with what you already have in place, what your financial assets are, what your real estate holdings are, and things that will enable the attorney to make suggestions to you based upon your specific needs. When we talk about the irrevocable trust, this trust is going to do so much more than the revocable trust if you will allow it to do so. I know it sounds daunting to hear the terminology irrevocable because we want the ability to change things or to cancel things. It's only human nature. Just remember that just because the trust is called irrevocable, it doesn't mean that it can't be revoked. It can be revoked. But what it means is that if it is revoked, whatever benefits you gained from it will be lost. So it's important to know that you want to utilize an irrevocable trust before you do, because otherwise you will have wasted the money that you spent on your legal fees and also wasted the time that you were waiting on toward the process of protection if you're only then going to revoke it. When you have the irrevocable trust in place, even though there is terminology in the trust that sounds like you're giving up control over your assets. In essence, I try to explain to our clients that that is not the case, because whoever you're choosing as your fiduciary, so this is going to be your trustee of the irrevocable trust. And by the way, you cannot be your own trustee of the irrevocable trust, whereas with the revocable, you can be your own trustee. The reason behind that is that Medicaid requires that distancing. If you could be the trustee, they would take the position that you had too much control over the assets, and therefore they wouldn't give protected status to assets that are titled in the irrevocable trust. But when you're using the irrevocable trust, whomever you choose to be your trustee or trustees should be who you know are going to carry out your wishes. And the attorney should explain to those people that they are acting in a fiduciary capacity to you, meaning that they have to always do what's in your best interest. And if you have mental capacity, what's in your best interest is really what you want done. It's only where you lack the capability of making decisions that your fiduciary should be substituting his or her thoughts or preferences as to what should be done. So I know that I, as an elder law attorney, explain all of this to the fiduciaries, who are typically the children of the grantors, at the signing meeting, and I instill in them that they have an obligation to do what mom and dad want. And I also remind them that mom and dad are typically doing all of this, are spending the money on all of this for the benefit of their children. Because honestly speaking, if mom and dad needed to spend all of their money and perhaps have a lien put on their house when they die for the cost of long-term care, they'll be deceased at that point, right? When it comes to fruition. So it'll be the children who will be left with little or nothing. So the parents are doing all of this generally for the benefit of their children and grandchildren or whomever their beneficiaries are. And the fiduciary needs to keep that in mind at all times. So let's see, what else do we have here? Okay, I noted when I was reviewing earlier that I did not, for some reason, include some slides with regard to some tips for small business owners in relation to estate planning. I am going to speak about that for a few minutes here, and Bart has assured me that when the slides are given to all of you, he can include those at that time. So you will actually have the slides, but I don't have them to share with you at the moment. I wanted to speak a little bit about buy-sell agreements in relation to estate planning. For those of you who maybe have small businesses and maybe either have buy-sell agreements in place or were contemplating having buy-sell agreements in place. And what a buy-sell agreement is really a legal agreement, a contract, where it allows for the owner of a business to prepare in advance for what should happen if one party or more than one party wants to be bought out at a certain point in time of their business interest, or if the individual dies and now the estate has to be bought out. The buy-sell agreement will have provisions in it kind of dictating what should happen under those circumstances. It also allows for the designation of who would run the business. Let's say if there are, 3 or 4 members of the business and one person dies, does it allow for the heirs of that person to come in and have a say in the business operations? And this is very important because many times that wouldn't make sense. Usually the heirs don't know anything about operating that particular business. And so to burden the surviving member or members of a business to have to now listen to what someone who wasn't a member and integrally involved in the business to now come in and say what should be, it's important to have that all ironed out and agreed to by the parties while they're, operating their business together. The buy-sell agreement, as I said, will also not only kick in upon death, but also upon retirement or disability. And many times we have disability insurance policies or life insurance policies that are going to be related to the provisions of the buy-sell agreement, and they will enable the survivors of the business to have the financial means to either pay the person retiring or the disabled business owner or the family of a deceased business owner to be able to pay them with the proceeds of insurance, as opposed to having to, wreak havoc on the business and come up with this sum of money. In the buy-sell agreement, it will also have formulas for determining what the values of ownership would be upon these important milestones in life: retirement, disability, and death. So it's a very important component to having your estate plan if you're a business owner. Also, another important concept that I would like to just spend a couple minutes on is utilizing the LLC, Limited Liability Corporation, in conjunction with estate planning if you are a business owner. And many times people will say to me, "Oh, but I have an LLC. Is that all I need?" And so the answer is really, it's not necessarily the be all and end all to your estate planning. It is something that has merit. And let's just talk about some advantages and disadvantages to the LLC, as also advantages to utilizing an irrevocable trust instead of an LLC under certain circumstances. So the advantages to utilizing an LLC is that it offers limitations of liability on the organization or the business's members. So when you own a business, if you title that business in an LLC, now your personal assets are not going to be vulnerable to something that occurs in the context of the LLC business, right? So that's very important because you don't want your, personal assets to be at risk if, let's say, there's some kind of loss in the business or lawsuit against the business or things of that nature. So the LLC will be the entity that would be viable for a claim to be posed against it, not your personal assets elsewhere. It's important, if you have a business, in my opinion, that you only have one business titled in one LLC. Don't commingle various businesses that you have. So, let's say if you have a business and that business owns real estate, I would have a separate LLC for your real estate and a separate LLC for the business ownership. again, we don't want to put more assets in the LLC than necessary in the event there is some kind of a claim for something that arises. We want it to just be limited to, if it's a fall on the property and the LLC called, Main Street Realty owns that building, that will be the only asset that can be vulnerable to that claim. Whereas if it's, let's say somebody is suing you for, some kind of malpractice or, failure to complete work on their home or something like that, it would only be the LLC of the business and the assets there that could potentially be vulnerable. And of course, you're always going to have the proper insurances in place. First and foremost, those things would be what would be looked at to satisfy claims. But we never know the extent of claims. And if there's any way that we can hedge our bets and our assets by having other things like an LLC in place, it's a good idea to have that in addition to the insurance coverages that you do have. The disadvantages of an LLC versus an irrevocable trust are that it does not avoid the probate process, having your assets of a business or real estate or whatever in an LLC. Because when you have an ownership interest in an LLC, you, the individual, own, we call it units of the LLC. Those units of the LLC are going to be part of your estate. So if you die and you own units in an LLC, your will would control the distribution of those units. So it would have to go through probate. But what we oftentimes do is in the estate planning, we assign those units to a trust that the individual created, be it revocable or irrevocable, so that now upon the passing of the LLC owner, those units can be distributed under the provisions of the trust that they were assigned to, thereby avoiding probate. So that's a pro of using an irrevocable trust or a revocable trust in conjunction with an LLC. Let's see, what else do we have? There are certain tax benefits to owning property in an LLC. I am not an accountant, and I would strongly suggest that you consult with your accountant before changing the status of your ownership interest at any time. Essentially, in order to establish a proper estate plan, whether you're a small business owner or an individual, it really does require kind of the cooperation of not only an estate planning attorney, but also an accountant and many times a financial advisor. So if you have trusted people in those roles, typically you're going to be in great shape because they will work together with the knowledge that each individual has in his or her own field to make sure that you're maximizing the tax benefits, the protections, and the conveyances in a simple way to your next generation. I believe I've covered everything that I wanted to cover today. I am here for as long as you need me to answer questions. So Gina, are you going to be, or Bart, are you going to be posing the questions to me, or how are
Gina,
we
do you want to take the questions to
Sure.
give Annamarie?
Sure. So there was a question, the slides and the video will be emailed to those using the email you registered for the workshop, for the webinar. So there is a question: for a caretaker child that has lived with you for 2 years prior to the disability, do those 2 years need to be the 2 directly preceding the disability?
Yes, it has to be for the 2 years immediately preceding the application for long-term care through the Medicaid program.
Okay. The other question was, can a business be placed in a trust? And I know you just spoke a little bit about what to do with an LLC. So you're gonna send some additional information on that, or?
Yes, I'm going to send the slides that have a little bit more information on that. But if someone has specific questions, I'm more than happy to have a meeting with them to go into their specific need.
If someone wants to reach out, speak to you directly, is the best way for them to email you with the information? Is that best, or?
Well, they can either call the office, which is on this last slide, actually, 718-816-0005. They can certainly email me. I think my email address is somewhere in the materials, but let me give it at this time. It is AGEN as in Nancy, TILE at lawnyc.com. And if you need to email me, I'll certainly get back to you and we can set up a consultation that way. We also have a website that I encourage you to go to, which is www.aglawnyc.com, because on that website, since our last presentation, we've implemented what's called ebooks, and these are electronic books, like little, scenarios and things like that, where people who have specific questions about elder law or any of the areas of our practice can log on and get the free ebook, and they can many times find answers to questions that they may have as well.
Okay, another question, is there a way to keep your home in your name, but transfer the deed to your children so you can still stay in your home and Medicaid cannot take it should you need to apply for Medicaid?
Okay, that's a really great question, and a lot of people do ask me that question. So thank you, whoever asked that. Years ago, I would say prior to 2006, there was a reason why people would say they wanted to put the house into their children's names as opposed to utilizing a trust. And the reason was because there was only a 3-year look-back penalty period if they did that, as opposed to transferring it into a trust where there was a 5-year look-back penalty period. But in 2006, that law changed, and all transfers became subject to the 5-year penalty period of transferring for institutional care. So we as elder law attorneys point out to our clients that the dangers of putting your property into individual names of your children or whomever well outweigh utilizing a trust, because when you put something into, let's say, your children's names, if anything happens in their lives, even unintended, let's say they have a car accident and it's a catastrophic injury and the insurance doesn't cover the amount of the claim, now the injured party can potentially put a lien on your house because you conveyed it to your children. So by utilizing the trust, it's kind of an intermediary. It doesn't vest in your children or whomever until you die, but yet it's not considered yours during your life for the purpose of being counted toward qualifying for long-term care. So it's really a win-win situation, and you retain the ability to sell that property if you want, or to, I don't know, renovate it or whatever you may want to do. And the beauty of it is that if you do decide to sell that property at any time, once it's in the trust, this is the irrevocable trust that we're speaking about, as long as whatever you do with the proceeds of the sale, so if you buy another property or you decide you're going to rent and you're going to invest that money in, an investment account, whatever you do with the proceeds of the sale of the trust property, as long as it's done in the name of the trust, it will be retroactively protected to when you protected your home in the trust or your real estate. So this is huge because it gives all the flexibility that you would have even with the house being in your own individual name, but yet you've protected it.
So there's a lot of questions about, you know, your contact information. All of that will be in the information that we send out. I just want to, you know, talk about my own personal experience. I did go through probate end of December for my mom, unfortunately, with a very, very good will. But I was told by many lawyers, because I contacted a few, in New York City, it can take anywhere from 6 to 12 months to go through probate. So that was, you know, so if you have to maintain a house or whatever, so it's very important. I was a little taken back. They're obviously behind in the courts, and I was fortunate. We had a very strong, well-written, well-documented will, and there were no issues, but they were shocked how quickly, and it took about 3 or 4 months, how quickly it went through. So that's just a personal note to sort of educate others.
And just to piggyback on that, another reason why it's important, or it should be considered at a minimum, to utilize a trust is because if you own real estate in more than one jurisdiction, so you know how some people have their house here, let's say on Staten Island, yet they have a summer home in Florida or North Carolina or Arizona, wherever they may go. If you don't have those properties titled in a trust, then your heirs are going to have to go through multiple probate proceedings because courts of one jurisdiction do not have authority over real estate in another jurisdiction. So it becomes even more of a burden and an expense and everything for people who have multi-state real estate holdings.
Okay, I think there's a final slide that if I don't have control of it, I don't know.
This
There
one
you
right
go.
here, you have
All
it?
right.
Yep.
There we
So
go.
just want to also thank Flagstar, who helped sponsor this webinar today. So we thank them for that. There will be, the information will be sent to you as well as a survey. I encourage you to fill out the survey. It helps us to bring topics such as today's to the forefront based on popular demand. So we're here to help you. And thank you all for attending today, and thank you and for your contribution, Annamarie,